same flight, same details. So why are these ones?
So for Halima, Halima has a mission. The mission is to confirm the investigation and also yes. If we have the comes into in a different one.
Sorry? In a different matter. Sorry?
John Minor. John.
alikuwa kesi ingine Kikuyu, hiyo story yake karibu ikufe sababu ya nini.
Habiba sana na kina Beka
Yes. Manzo, I do appear for your lordship was for the subject for the conference. She's here.
Council, I'm sorry to disappoint you. So I was not able to do the ruling and complete it in time. I don't know, how is tomorrow?
My Lord, I do believe that tomorrow is marked as Sabasaba. Therefore, if the court...
Actually, what is likely to happen?
You know that the Kenya has become a country whereby everybody is a protester. We are not very certain.
At least not us.
Yes. But in the event, my Lord, I think I'll be available to appear. And virtually or even in person.
Let's agree. When was she released?
She was released, my Lord, at 10 minutes before 5 p.m.
On Friday?
On Friday.
I thought, and I was a bit worried when I saw something suggesting that somebody
Yes.
had not.
I had already even prepared the draft to...
Okay.
Opportunity to vent out only one issue,
Which is?
perhaps that might require your consideration in regard to the nature of that application that forms the subject of the review.
The application in the lower court?
Yes, my Lord, I am aware that you must be having the distress application.
Yes, I can see there is one here.
And the only thing, my Lord, I want to point out is the abuse of the process, my Lord.
Of these applications?
Yes, my Lord. And its constitutionality.
Custodial.
I'll draw your attention to paragraph 5, 6, and 7 of the said of supporting affidavit.
5, 6, 7.
Well, at paragraph 5, the deponent, one Mr. Edwin Meto, indicates that on the 10th of June 2026 at 1:06 p.m., the user, who is now the subject applicant herein, made another publication indicating that the president was flying from Norway to Finland on board a private jet. My Lord, you realize that this is an averment of facts. And being an averment of facts, my Lord, a judicial officer cannot be in a position to test the veracity or the authenticity of that averment in the absence of evidence. That is to say, my Lord, none of us as Kenyans knows whether the president was on board that flight or not in the absence of a manifest. And a manifest, my Lord, you find it under the Civil Aviation Act. And my Lord, the reason why I'm pointing out paragraph 5 is because paragraph 7 would not stand in the absence of the averment under paragraph 5. Paragraph 7...
Sorry, let me get you. Unnecessary document.
Yes. So that, my Lord, paragraph 7 can have some legal footing and factual footing. And I'll submit on it, my Lord. They say, and equally paragraph 6, but paragraph 7 is what is of most importance because it's now the one that is now criticizing into the alleged offense. they say that the motive of the alleged tracking remains unknown, and the information published by the said user has caused apprehension on the person of the head of state. The deponent is presupposing that the head of state was on board that aircraft. Yet none of us knows whether or not he was actually on board. So, my lord, how can an offense crystallize? Because an offense must be based on facts.
But Mr.
Yes, my lord.
The basis would be this kind of information.
Yes, my lord.
Then what I hear you arguing now would be a matter in challenging the charge.
That would be correct, my lord. But remember, the charge will be informed by the information extracted from this particular
devices.
application.
Okay.
This is a device. Actually, this application is a device. Is a facilitator. So, in that sense, my lord, this application itself amounts. A JO would ordinarily not have the basis upon which an application such as this one would be admitted. 43. Then you realize that this application breaches and violates Article 50, a right to fair hearing. Because an applicant such as Halima or the defense would never have the opportunity of testing the veracity of this alleged apprehension. We will never have Mr. William Ruto appear before any judicial officer for averment, for ascertainment of these averments. So the premises on which this application itself is premised on, my lord, it's itself unconstitutional. And we are asking this court, my lord, pursuant to Article 165, to pronounce itself on the constitutionality of such an application, where application is premised on violation of a right to fair hearing. And my lord, you might even want to go further and deploy your tool of supervisory jurisdiction to supervise whether or not, my lord, such an application is tenable. Lord, we may avert future abuses, my lord, because we are not sure where the president will go tomorrow, whether our personnel will be able to track or not.
Okay, Mr. Njiru, 143,
yes,
and talk about the immunity.
Yes, my lord.
Are you by any chance suggesting that because of that immunity, the head of state is not entitled to protection of the law?
He is entitled to protection of the law, but he cannot invoke criminal jurisdiction in his own capacity. And an application such as this one cannot have the reference or cannot refer to him as a man complaining about the apprehension, because you'll never have him on the dock at any given time.
As the complainant?
Yes, as a complainant. Therefore, you'll never be able to test the veracity of the averments of apprehension. Me, I felt I was apprehensive.
Okay,
Yes,
that's your point.
We are most obliged.
Thank you.
Which is still on air today. The deponent has not indicated that it was the designated presidential jet that was tracked.
Okay.
That's the conundrum in this application, my lord.
You've expanded the scope of your application. Let's do this. Okay. Something. In 2026 at 9 a.m. virtually. I'll be out of station, so I'll deliver it from wherever I'll be on Thursday. Okay?
Most obliged.
Okay.
My lord.
Yes.
Most obliged.
Okay, thank you.
Findings.
Okay, the intended offense.
Yes, lies under the Cyber Crimes Act, Section 27, which has actually been declared unconstitutional, and avoiding the substantive law, which is the Civil Aviation Act. Number
Crime.
21 of 2013, Civil Aviation. You can see the mischief, my lord, because they know that if they were to go under the Civil Aviation Act, the ADSB will be applicable. We are most obliged.
Okay. Thank you.
Your Honor, I wish to bring to your attention, dated the 6th of July, 2026, which have been brought before you under false pretense and misrepresentation of today's mention is for the investigators to confirm where they've gotten as far as the investigation is concerned, and
yes,
whether there is any
I'd rather
charge.
they confirm that first, because as far as I'm concerned, the 3 days I gave are over.
Yes.
Yes, Your Honor, the IO is in court.
Your Honor, I'm the investigating officer in this matter. Investigations are still ongoing. My number, I'm number 80487. Corporal Edwin Meto, Your Honor. Investigations are in progress. We have not completed. On 2nd of July 2026, we sought court orders under miscellaneous application number E2972 of 2026, seeking orders to allow us conduct forensic examination to allow us complete investigations. The respondent was released on Friday following a court order in High Court, which instructed us that the respondent be released. That's all, Your Honor.
You know, we've had the testimony over the same matter. And before the High Court, Your Honor, we have challenged some of the averment contained in the affidavit, the constitutionality of the process, and all that the ODPP has made an application to be granted more time to investigate, my Lord, Your Honor. I'm just wondering where that is premised on. Yes?
It's not in that file.
It's not in the file. But Your Honor, you on one thing. Yes, on one thing, Your Honor, if you allow me, you may decide whether or not it is legally relevant. The most important thing the IO has indicated to you is that they are investigating forensically the confiscated gadgets. Those gadgets, Your Honor, the IO is investigating are the ones contained in this inventory. So by way of backdoor, they have introduced this inventory. Why it is not before you, Your Honor, is because they want to conceal the manner in which these gadgets were confiscated. The propriety of the confiscation. All what I wanted to point out to you, Your Honor, is that these gadgets were confiscated in the absence of or in breach of the procedure contemplated by Cap 75 and in the absence of a search warrant. Yes, Your Honor? Extend orders for investigations based on gadgets that were unlawfully procured. How do we deal with that conundrum? Because it is you now who has a jurisdiction to say, go on with the investigation. If you order so, they will be investigating these gadgets that were unlawfully procured. How do we resolve that conundrum? because it's you with the jurisdiction.
What was the High Court done?
The High Court has just given us a date for Thursday for a ruling.
Because I believe that is before the High Court.
Yeah, but then it's not before the High Court. It's before Your Honor, because the gadgets were subject for investigations. Your Honor, are the gadgets subject of the investigations not before you? Because he has made. But Your Honor, there's a legal issue I'm pointing out. And the legal issue is that the gadgets that you are just about to extend the orders for investigations were unlawfully procured. They deliberately refused to give you the inventory. They never annexed it. Even the manifest itself was never annexed to see whether Mr. William Ruto was on board that flight or not. That's the legal propriety I'm indicating to you, my lord, Your Honor.
Lady, I don't believe that your hands are tied on this particular matter. I don't believe so, and this is why I want to, I'm on my feet. The application before the High Court, I'm the advocate who drafted that particular application. The issues that I raised in the High Court were on the issues as far as how the custodial orders were obtained. My lady, what is before you is an issue as in reference to a search warrant which has been granted. And ideally, when the arrested person was presented before you, on the initial miscellaneous application in 2922, my lady, there was no iota of evidence that was attached on that miscellaneous application. None whatsoever. And because the fact...
that one is done, it was spent.
My lady, then...
I had it and I gave 3 days.
My lady...
I sold 7 days, I gave 2. 3 are over.
Then, my lady...
But you are not happy with the 3, you moved to the...
We did move to the High Court because there was the court in itself which granted the orders was actually misleading to actually granting those particular orders.
Or not. So that then we close this matter, we close this file.
This file has come for closure.
All right, if that's the case, then let's proceed and have the orders.
Then in that point, he should be actually be ordered to release those particular gadgets because he has not appeared before the High Court to address this particular inventory. He is involved. The DPP is involved.
DPP was there.
Let's close the file. Let's proceed to close the file, then we shall make the subsequent orders.
If I may.
Was arrested, who is a lady, was searched and arrested by 3 men and was transported from Mombasa to Nairobi under the custody of those 3 men, Your Honor. The standing orders of the police under their act require that a lady is arrested in presence of a lady officer and also searched in presence of a lady officer. So, Your Honor, I think it's within your jurisdiction, and if the IO can explain, so that this sort of situation is not repeated for the decency of any person being arrested.
Gadgets which were seized when the respondent was arrested. That is the investigation that the investigator is indicating. That is ongoing. And we are requesting for more time to have the report, the forensic report. So we're not closing the miscellaneous at this point to prejudicial.
May we then get your directions as the fate of the matter before you, granted that the fact that the court is of the view that it is functioned as official. And I agree with you because... Yes?
As far as I'm concerned, there is
application before you for extending of time. All right, let me wait for you.
No, the investigating officer has made the letter.
All right. lady, then let
My days was 3. You were not there, so you have come here to take the court back and to create confusion. Because if you were not there, you were not there.
That's the second application.
That's the second application. The orders for search were issued under 2972. So under 2922, it's only custodial. Yes, Lana, that is enough.
Next one.
Lazima muulize swali.
Like from your heart. Yeah. Okay. Just speak what happened to you. Don't be afraid.
Kwanza nashukuru Mungu kwa kuni. Also I'd like to thank my lawyers, my legal team. They really supported me. They're really supporting me up to this point. Yeah. That's it.